A lot of times I'm asked, what happens during the case? Like any other lawsuit, a complaint is filed and the defendant needs to file a formal answer. Typically, the complaint is mostly boilerplate, and of course, so is the answer. The defendant may, and that's true mostly in preference cases, the defendant may also choose to file a motion to dismiss the case on various grounds. In fraudulent conveyance litigation, the complaint must be more detailed because fraud is typically alleged. So motions to dismiss vague complaints are fairly common in fraudulent conveyance litigation. The answer in fraudulent conveyance cases must also be more detailed and specific. After the answer is filed, typically the next thing that happens is a status conference, during which the bankruptcy judge will set out the relevant deadlines in the cases. The status conference usually takes place about 30 days after the answer is filed. Since the trustee is usually suing a number of different defendants, the judge will usually not go into the facts of the case for any particular defendant during the status conference. In the Enron case, over 5,000 cases were filed. It's not unusual to have 200 or 300 cases filed at the same time. The status conference will set a deadline for discovery, expert reports, and other matters. After the deadlines are set, typically discovery starts immediately. Usually, discovery lasts 3 to 6 months. After discovery is over, one or more of the parties may file a so-called dispositive motion. These motions ask the judge to rule on the case without a trial. The theory is that there are no real, genuine facts in dispute, so the judge does not need to see and hear live testimony because the judge doesn't need to decide any facts, doesn't need to judge the credibility of any witnesses. These motions, these summary judgment motions, typically take a couple of months to be filed and heard. If those motions don't resolve the case, the judge might set the case for mediation or set a deadline for trial. Trial is usually scheduled 2 or 3 months after the deadline for dispositive motions. Usually there's motion practice before trial. For example, one of the parties may want to prohibit the judge or whoever the fact finder is, perhaps a jury, from hearing certain kinds of evidence. After the trial, there may be post-trial briefs that are filed, and after those, the court will issue a ruling. 99% of cases, maybe even more, are settled by negotiation during mediation, or resolved through motions for summary judgment, or motions to dismiss, or through negotiations at any time during the case. If the case is not resolved and goes all the way to trial, the time frame from the beginning of the case to the trial is at least 1 year minimum in my experience.